So imagine you spend like 10 years painstakingly crossbreeding this perfect drought-resistant tomato.
Right, a massive investment of time and money.
Exactly. You finally get it right, you plant your crop, and then a massive storm hits.
Oh, no.
Yeah. The wind blows thousands of your specialized seeds over the fence and straight into your neighbor's commercial farm.
Wow.
And then the next season, your neighbor is just, growing and selling your miracle tomato. Did they just steal your property?
Mm-hmm.
Or is it just nature taking its course?
That is it's the perfect hypothetical because it gets right to the heart of what we're dissecting today.
Welcome to the wild, invisible world of intellectual property.
Because when the property isn't a physical object, but the idea or like the genetic code behind the object, the traditional rules of ownership just completely fall apart.
They really do.
Mm.
And if you were listening to this, you're likely prepping for your Osmania University LLB semester the 7 exam.
Right, the intellectual property law paper.
Specifically Unit I, which, let's be honest, can feel like an absolute maze of statutes and overlapping treaties.
It's dense. Very dense.
So our mission today is to build a mental map of these concepts for you. We're going to transform all that dense legal jargon into an intuitive framework so you can walk into that exam and absolutely nail it.
Basically, we're looking at the legal architecture of human creativity.
I love that phrase, the legal architecture.
Yeah, and to understand that architecture, you first have to understand why the system was even built in the first place.
Right.
Intellectual property refers to the creations of the human mind, right? Human intelligence. It's the product of human intellect, so inventions, literary works, symbols, designs used in commerce.
And the purpose.
The fundamental purpose here is to incentivize people. We want them to develop creative works that benefit society, ensuring they can actually profit without fear of, misappropriation.
Okay, let's unpack this, because the very first thing we need to wrap our heads around is how intellectual property differs from traditional property.
Right, the physical stuff.
Exactly.
Yeah.
Like if you own a piece of real estate, say a house or a farm, you can build a physical fence around it to keep people out.
A literal brick wall.
Yeah.
Yeah.
If someone crosses the fence, it's trespassing. It's clean, it's geographic, it's obvious. But if you invent a revolutionary new concept or write a brilliant song, you can't exactly build a brick wall around an idea.
It really can't.
So the law has to step in and build a legal fence.
That is honestly a brilliant way to frame it. The law grants exclusive rights because you can't lock an idea in a vault and still benefit from it commercially.
Put it out in the world.
Exactly. But these legal fences have 5 specific vital characteristics that separate them from physical property.
Okay, I want to challenge the very first characteristic on that list, which is that IT is territorial.
Ah, yes.
Because, if I own a physical farm in Maharashtra, the border is indisputable.
Yeah.
My farm isn't going to suddenly cause a legal dispute in Paris.
Right.
But how does an idea have a border?
That exact question is the logistical nightmare at the center of international IP law. Oh, absolutely. Any intellectual property right issued is, generally speaking, resolved by national laws.
Okay.
So your Indian patent protects you in India. But what happens when a brilliant industrial design created in China is suddenly imitated and manufactured by a competitor in France?
Oh, wow.
Right, and then sold online to a consumer in the United States. The market isn't local anymore, it's inherently global, which makes territoriality a massive, massive hurdle.
So you have to build those legal fences country by country.
Pretty much, yeah. It's exhausting.
Which sounds incredibly expensive for the creator. But territoriality is only half the battle, right? Even within your own borders, you need the legal right to actually keep people out. Which brings up the second characteristic, exclusivity.
Yes.
You have the exclusive right to use, manufacture, and sell your creation. Nobody else can touch it without your permission.
However, that exclusivity comes with a major caveat, which brings us to the third characteristic. It's subject to public policy.
Right. The greater good.
Exactly. Intellectual property attempts to preserve a very delicate reconciliation between 2 competing interests.
Okay, what are they?
Well, yes, the rights holders require adequate remuneration. They need to get paid. But society needs to progress.
Right. You can't just halt all human advancement.
Exactly. You cannot have a legal monopoly that starves the public of life-saving medicines or critical technologies.
Oh, that makes sense.
So the law explicitly designs these rights to expire or be subject to compulsory licensing in emergencies, ensuring the public ultimately benefits.
It's a calculated trade-off.
It really is.
And we also have the characteristic of being assignable, meaning you can separate the intellectual property right from the material object itself. Like you can buy, sell, or license the rights.
Exactly. You can sell a physical paperback book to someone, but you are not selling them the copyright to the story printed on the pages.
Right. They own the paper, you own the narrative.
Exactly.
Which leads us perfectly to the final and, frankly, most complex characteristic, independence, meaning different intellectual property rights can subsist in the exact same object. I really want to test this idea.
Okay, let's do it.
Because when we look at the main forms of intellectual property, there is a massive divide between industrial property, like patents and designs, and copyrights.
Right, the two big pillars.
So if I create a beautiful, sleek new machine that also has a revolutionary, never-before-seen engine, inside which IP am I actually using?
What's fascinating here is that you wouldn't just use one, you would use a combination.
Really?
Yeah, the modern smartphone is the ultimate example of this. Think of a cell phone not as a single product, but as a Russian nesting doll of independent legal rights.
Okay, wait, I love that. Let's peel back the layers of that nesting doll. Let's start with the functional stuff inside.
Okay, so the revolutionary circuitry, the antenna technology, the way the battery communicates with the processor,
Yeah.
that is protected by a patent. To get that patent, the invention must be of practical use, it must be novel, and crucially, it must involve an inventive step.
An inventive step. What does that actually mean in practice?
It means a person with average, ordinary skill in that specific field wouldn't have just obviously deduced it. It has to be a true leap forward.
Okay, wait. If the patent strictly covers the function and the utility of the phone, what stops a competitor from legally making a phone that works differently on the inside but looks exactly the same on the outside?
Like a clone.
Exactly. Just a total blatant visual ripoff of your sleek design.
Ah, that is exactly why the next layer of the nesting doll exists. Industrial design.
Okay.
Industrial design rights protect the aesthetic, non-functional aspects of an object. The three-dimensional shape of the phone, the specific bevel of the screen, the pattern of the casing.
So it's all about how it looks.
Entirely. It must be new or original and strictly non-functional. If the shape helps the phone work better, it's a patent issue.
Right.
But if the shape just looks incredibly cool and distinctive, it's an industrial design issue.
Okay, so we've protected the engine with a patent and the sleek aesthetic with an industrial design. What about the tiny silicon chips inside? Like the physical layout of the microscopic wires?
That falls under a highly specialized category called layout designs of integrated circuits.
That's a mouthful.
It is, but the architecture of a semiconductor is so complex and takes so much investment to design, but it's incredibly easy to copy once it's manufactured.
Oh, I see. You just scan it and print it.
Basically, yeah. So specific laws protect the three-dimensional disposition of the elements of an integrated circuit.
And then, obviously, the phone needs an operating system to actually do anything.
Precisely. The thousands of lines of software code running that operating system, that falls under copyrights.
Wait, really? Copyrights, like a book?
Yes, copyright protects literary and artistic creations. In the eyes of the law, software code is treated as a literary work.
That's wild. And finally, to make sure the consumer knows who made this masterpiece, you stamp your logo on the back.
The trademark, a distinctive sign that identifies the goods, helping consumers quickly identify and purchase a product they trust.
And it keeps competitors from passing off their cheap knockoffs as your premium product.
Exactly. One physical object, 5 completely independent legal fences.
That Russian nesting doll analogy really clarifies things.
Mm-hmm.
But so far, we've only talked about the absolute originators, like the inventors coding the software or engineering the battery.
Primary creators, yeah.
What about the people who bring an artistic creation to life? Imagine a brilliant songwriter writes a mathematically perfect but incredibly boring song on sheet music.
Okay.
Then a charismatic singer gets hold of it, belts it out, adds their own vocal flair, and turns it into a global platinum hit. Who owns the magic of that hit?
That's a great question.
Because the songwriter owns the copyright to lyrics, sure, but what does the singer get?
You've just hit on a vital and heavily tested area of your syllabus called neighboring rights or related rights.
Neighboring rights, okay.
They are closely associated with copyright, but they protect a completely different set of interests. They primarily benefit the performers, the singers, actors, and dancers.
So not the writers, but the performers.
Exactly. They also protect the producers of phonograms, which is just the legal term for sound recordings, and the broadcasting organizations that transmit the work to the public.
The unsung heroes of the creative industry.
Yeah.
The people who actually deliver the art to us.
Exactly. And in India, the Copyright Act of 1957 carves out specific statutory protections for them. Section 38 deals with performers, giving them the exclusive right to make sound or visual recordings of their performance.
And then Section 39.
Section 39 grants similar rights to the producers of those recordings, and Section 39A handles the broadcasting organizations.
And we can look at a landmark Indian case to see how this actually works in practice, right? Phonographic Performance, Ltd. Collector of Customs from 1979.
Yes, a very important case.
In this case, there was an unauthorized importation of phonographic records. And the Supreme Court of India didn't just look at the copyright of the underlying song. They ruled that importing these records without proper authorization violated the neighboring rights of the performers and the producers.
Right. It proved that these related rights have real enforceable teeth. They aren't just suggestions.
It's so interesting to see how different jurisdictions handle this, though, because globally, there's a massive philosophical split.
Oh, absolutely.
Like the Rome Convention in 1961 tried to establish a global minimum standard for performers and broadcasters. But if you look at the United States today, they still rely heavily on private, contractual agreements and union licensing arrangements to protect performers.
It's very market-driven over there.
Scary.
Indeed. Contrast that with the European Union and India. The EU has incredibly comprehensive, strict legislation.
Like what?
For example, the 2019 EU Directive on Copyright in the Digital Single Market even introduced brand new neighboring rights specifically for press publishers and news agencies.
Oh, wow. What?
To ensure they get paid when massive online platforms, aggregate their articles.
Right, like search engines just pulling their headlines.
Exactly. And India leans heavily toward the EU model, strong, non-negotiable statutory protections to ensure fair compensation, rather than leaving performers entirely to the mercy of contract negotiations.
Speaking of different strategies for protection, I wanted to pivot to a form of IP that almost feels like the anti-patent. Trade secrets.
Ah, the anti-patent. I like that.
Well, we established that a patent is a quid pro quo. You get a legal monopoly for 20 years, but in exchange, you must publish your exact blueprints to the public.
Right.
But what if you never want the public to know? You use a trade secret, which is undisclosed business information, manufacturing formulas, algorithms, highly guarded client lists.
The mechanism of a trade secret is entirely reliant on concealment. And what makes them so incredibly powerful is their duration.
Because they don't expire.
Exactly. A patent expires. A trade secret has no time limit. It continues indefinitely, forever, as long as the information continues to meet the legal definition of a secret.
So what does this all mean? The quintessential example here is the formula for Coca-Cola, right?
The classic example.
John Pemberton invented that syrup in 1886. If he had filed for a patent, that formula would have entered the public domain before World War I.
Right. Anyone could legally manufacture and sell the exact same Coca-Cola today.
But because the company chose to protect it as a trade secret, locking the recipe in a vault, limiting access to a tiny fraction of executives, they have maintained a commercial monopoly on that specific formula for well over a century.
Exactly. The law provides protection against the illegal misappropriation or corporate espionage of that secret. If a competitor bribes a Coca-Cola employee to steal the recipe, the law will crush them.
Right.
But, and this is the critical vulnerability, the burden is entirely on the owner to reasonably attempt to keep it confidential.
You have to actually try to keep the secret.
Yes. Furthermore, if a competitor independently reverse engineers the formula without stealing it, the trade secret offers zero protection.
Oh, wow. So if someone just figures it out by tasting it and mixing things in their kitchen, they can use it.
Exactly. It's a high-risk, high-reward strategy.
Here's where it gets really interesting for me. Trade secrets, semiconductor layout designs, high-tech patents. They represent this very corporate, industrial side of innovation.
They do.
But your LLB syllabus dedicates a massive amount of focus to a completely different ecosystem. What happens when intellectual property isn't created in a Silicon Valley laboratory, but by local geography, unique soil conditions, or generations of traditional farmers?
Now we're diving into geographical indications and the protection of plant varieties.
The roots and the soil.
Literally, this is where IP law intersects with cultural heritage and agricultural survival. Let's start with geographical indications, or GIs.
Okay.
A GI is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that are intrinsically linked to that origin.
The classic Indian examples being Darjeeling tea from West Bengal, and Alfonso mangoes from the Konkan region of Maharashtra.
Perfect example.
The soil, the climate, the traditional harvesting methods, they physically alter the final product. You can't just grow a mango in a climate-controlled greenhouse in Europe, slap an Alfonso sticker on it, and call it a day.
No, you can't.
The GI tag ensures authenticity.
Precisely. In India, this is governed by the Geographical Indications of Goods Act of 1999. It fulfills India's obligations under the WTO's TRIPS agreement.
Which requires member nations to actively prevent the use of GIs for products not actually originating from the indicated area, right?
Exactly.
And it isn't just about civic pride, it's about raw economic survival for these regions. Look at the Kashmir Pashmina versus Nepali Pashmina case.
A very significant dispute.
This wasn't just a naming dispute. You had unscrupulous traders mass-producing inferior machine-made fabric and passing it off as authentic hand-spun Kashmiri Pashmina.
Undercutting the real artisans.
It was diluting the reputation of the product and literally destroying the livelihood of traditional weavers. The GI registry stepped in to enforce the standard, proving that GI tags are essential for preventing market confusion and protecting regional economies.
Which is a perfect segue into arguably the most complex high-stakes statute in this entire unit. The Protection of Plant Varieties and Farmers' Rights Act, 2001, commonly known as the PPVNFR Act.
Right.
India ratified the TRIPS agreement, which strictly mandates that member countries must provide protection for plant varieties. You can do this through patents or through a sui generis system.
Sui generis meaning unique, right?
Yes, a unique, custom-built system designed specifically for that country's agricultural landscape.
And India chose to build its own sui generis system with the PPVNFR Act because the tension here is explosive.
Oh, very much so.
On one side, you have multinational biotech corporations investing billions of dollars to genetically engineer crops that resist pests or survive droughts. On the other side, you have indigenous farmers who have been saving, trading, and slowly cultivating seeds for millennia. How does a law even begin to decide what qualifies as a new plant variety that can be exclusively owned?
Well, the Act uses a rigorous mechanism called the NDUS criteria.
NDUS.
Right. To be eligible for registration, a variety must prove novelty, distinctiveness, uniformity, and stability.
Okay, let's break down why those specific words matter. Novelty and distinctiveness make sense. It has to be new and clearly distinguishable by at least one essential characteristic from any other known plant.
Exactly.
But why do we legally care about uniformity and stability?
Because of the biological reality of farming. Uniformity requires that if you plant a field of these seeds, all the plants will share the same characteristics, subject to normal environmental variation.
So you can't have random surprises.
Right. You can't sell a registered variety where half the field grows tall and the other half shrinks.
Makes sense.
Stability is even more critical. It means the plant's essential characteristics remain unchanged through successive generations of propagation.
Okay, meaning what exactly?
If a farmer buys an expensive registered seed, but the second generation mutates back into an ordinary low-yield plant, the registration is meaningless. The innovation has to hold up genetically.
Wait, if this is all about incentivizing new lab-engineered innovation, I have a major question. The Act also explicitly protects things called extant varieties and farmers' varieties.
Yes.
If an extant variety is something that is already in the public domain or common knowledge, how can someone suddenly claim exclusive rights to it? Doesn't that just steal what already belongs to the public?
It is a brilliant question, and it is exactly why the PPVNFR Act is so unique. An extant variety can be registered without needing to prove novelty. It just needs distinctiveness, uniformity, and stability. A farmer's variety is one traditionally cultivated and evolved by farmers in their fields over generations. The law allows these to be registered not to allow corporations to steal them, but to allow the farming communities themselves to formally claim ownership and prevent biopiracy.
Oh, wow.
It stops a foreign company from taking a traditional Indian seed, tweaking it slightly, and claiming it as their own invention.
So it's both a sword for the biotech companies and a shield for the traditional farmers.
Beautifully put.
But when push comes to shove, what actual rights do they each get?
Once a new variety is registered, the commercial breeder gets exclusive rights to produce, sell, market, and export that variety for a specific period, typically 15 to 18 years.
Okay.
But, and this is the cornerstone of Indian agricultural IP, Section 39 of the Act explicitly guarantees farmers' rights. A farmer is legally entitled to save, use, sow, resow, exchange, share, or sell his farm produce, including the seed of a protected variety.
That is huge. They can literally resow the patented genetic material, was the catch.
The only major restriction is they cannot sell branded seed of a protected variety in a commercial package.
Got it.
They can trade it over the fence with their neighbor, but they can't set up a competing seed company.
And there's also researcher's exemption, right?
Yeah.
Which allows scientists to use registered varieties in their labs to create even newer varieties, ensuring a single corporation can't roadblock scientific progress.
Exactly.
But this beautiful, delicate legal balance crashed head-on into harsh reality with the Monsanto litigation. This is where the legal theory hits the dirt.
If we connect all these pieces to the bigger picture, the case of Nusivedu Seeds Ltd Monsanto Technology is the defining intersection of patent law and plant variety law in India.
Right. And just to be completely clear to you listening as your study guides, we are looking at this strictly from a legal mechanics perspective.
Yes, absolutely.
We are analyzing how the statutes collided, not taking a stance on the broader politics of biotechnology. So mechanically, how did the Supreme Court untangle a patented gene sitting inside a protected plant?
It required surgical legal precision. The Supreme Court upheld the validity of Monsanto's patents on the bee cotton technology itself, meaning the method and the genetic modification were validly patented under the Patents Act.
Okay, so the lab work was patented.
Yes. However, they clarified a vital point of hierarchy. When it comes to the actual seeds and plants, the PPVNFR Act prevails over general patents.
Meaning you can patent the microscopic gene in a lab, but the moment that gene is inserted into a seed and that seed is put into the soil, it is governed by the plant variety laws, which include all those farmer protections we just discussed.
Exactly. India firmly relies on its sui generis PPVNFR system to govern plant varieties, attempting to balance breeder innovation with the right to food security.
That's a very fine line to walk.
It is. And to manage the inevitable financial friction, the Act includes a benefit-sharing mechanism.
How does that work?
When commercial breeders utilize genetic resources or traditional knowledge to create a new, profitable variety, a portion of the royalties collected must be deposited into a national gene fund.
Oh, that's interesting.
This fund is specifically used to support and compensate the farming communities that preserved those genetic resources in the first place.
So bringing it all back to your LLB SEM prep, intellectual property isn't just a dry list of acts from 1957 or 1999 or 2001.
No, it's very much alive.
It is a living, breathing ecosystem of legal fences. You have patents protecting the functional engine of a smartphone, industrial designs protecting its aesthetic curves,
Right.
and copyrights protecting the code that runs it.
Right.
You have GIs fiercely protecting the geographic soul of Darjeeling tea, and the PPVNFR Act acting as a referee between a multinational's genetically modified seed and a traditional farmer's fundamental right to resow their harvest.
It is a comprehensive framework designed to incentivize the greatest achievements of the human mind, while ensuring that society actually gets to enjoy the fruits of that intellect.
Which brings us to a final thought for you to chew on before your next study session. Early on, we established that intellectual property is inherently territorial.
Right, it relies on national borders.
And domestic courts. But think about the world we live in right now. Like our opening example, a patented genetically modified seed could be blown by the wind across a national border.
Easily.
A copyrighted piece of generative AI art is instantly accessible globally the second it hits a server. So this raises an incredibly urgent question. As we move deeper into a completely borderless digital and genetic reality, will national laws like the Indian Copyright Act or geographically bound GI tags eventually become obsolete?
It's a huge question.
Are we inevitably heading toward a single, borderless global IP system?
That tension between national borders and borderless innovation is frankly the defining challenge for the next generation of lawyers.
Something to ponder as you crack open those textbooks.
Okay.
Good luck on the exam.